record. Okay, we're on the record calling docket number 21-UST-EA-02, Department of Health of the State of Hawaii versus Respondent, United States Department of the Navy. This is a continued evidentiary hearing on the merits and closing arguments. May I please have appearances of counsel? Let's go in order. Mr. Hargrove.
Good morning. This is Wade Hargrove, Deputy Attorney General for the Department of Health.
Good morning. Ms. Gannon.
Good morning, Hearing Officer Day and Counsel. My name is Ella Foley-Gannon. I'm with Morgan, Lewis & Bacchius. I have my colleague here, David Brown, also of Morgan Lewis, and Jeff Lau of the City and County of Honolulu. Also in the room with us here physically is Uge Moman, also from Morgan Lewis, and we represent the Board of Water Supply.
Thank you very much. Now, Mr. Henkin.
Good morning. My name is David Henkin. I'm an attorney with Earth Justice, and we represent Sierra Club.
And I did forget to mention that Erwin Kawada, our client representative of the BWS, is also in the room.
The figurative room.
The virtual room, right.
Mr. Jensen.
Good morning. My name is Craig Jensen. With me in the room is Dave Fitzpatrick, and with us virtually are Marnie Riddle and John McKay, and we represent the Department of the Navy in this matter. Thank you.
Okay, we're going to do just the final housekeeping matters regarding exhibits. Since yesterday, I believe now, we have exhibits filed that were supplements to the record. One from Sierra Club, that was exhibits. Let's see here. Just say it for the record. Exhibit S30 or S40. We had, and that's been uploaded to the database with an amended exhibit list. We have with BWS, let's see here. So 4 exhibits, and this would be, I believe, you correct me if I'm wrong, this is B422, B423, B424, and what is the fourth one?
B361.
B361. And these have been uploaded into the database?
That's correct.
Okay, and we have an amended, updated exhibit list. And then just before we got on, we received an amended exhibit list from the Navy with exhibit N-7N added to the record. And I believe that has been uploaded, correct?
That is correct.
Okay. Is there any other exhibit that needs to be added this time besides the motion to admit exhibits that we had, that was just filed this morning?
Not from the board.
Not from Sierra Club. I should mention that Sierra Club representative Wayne Tanaka has just entered the virtual room.
Okay. Thank you. Welcome. Welcome, Mr. Tanaka. Okay. Seeing none, let's just move on quickly to the motion to admit exhibits that was filed this morning by the Navy. This is exhibits N-70 and N-7P. This is a request to supplement. I'll just go around. Mr. Hargrove, any objection?
No objection. Thank you.
Ms. Gannon?
No objection.
Mr. Henkin?
We're deeply concerned that we did not have the opportunity to see these exhibits during yesterday's proceedings, that we were deprived of the opportunity to cross-examine. Just wanted to say that for the record. Our position is that the truth is on our side in this proceeding, and so if these are materials that the Navy wants to present, then we have no objection. So
noted. Without objection, these are admitted into evidence. This is exhibits N-70 and N-7P. The Navy can, oh, pardon me, Mr. Oh, Mr. Jensen, do you have something to say? I'm sorry.
Yes, I'd just like to proffer for the record and the viewing public that these two exhibits consist of a media release from the Department of the Navy dated November 29th, 2021, informing the public of the groundwater contaminant or of the potential for water contamination in the drinking water, and subsequently a newspaper article or an article from the Hawaii Public Radio's website dated November 30th, advising the public also with regard to this media release. And it goes to counter the claim that the Navy did not notify the public with regard to the contamination issue until the 3rd of December. Thank you.
With due respect, that's a mischaracterization of the media release. The media release states that guidance for only residents of the Joint Base Pearl Harbor Hickam military housing, so not AMR or anyone else, those people were advised by the Navy that if they smell fuel in their water, maybe you don't want to ingest it. That's N-7O. So no, it's not a general notification of the public. It's not a statement that things aren't safe to drink. It's if you smell fuel, don't drink it if you live at Joint Base Pearl Harbor Hickam. N-7P is a news report that accurately says that the Navy made that recommendation. It says U.S. Navy recommended Monday night that Joint Base Pearl Harbor Hickam military housing residents avoid ingestion of their potable water as a cautionary measure, quote, if chemical or petroleum odors are present, end quote. The news report is also accurate, saying, quote, the State Department of Health went a step further Monday and recommended that all Navy water system users avoid using the water for drinking, cooking, or oral hygiene. That is not with respect to if you smell anything, because if you smell anything, they also said if you detect a fuel odor from your water, you should avoid using the water for drinking, cooking, bathing, dishwashing, laundry, or oral hygiene. That's what the Department of Health said. And it also correctly notes but the commander of Joint Base Pearl Harbor Hickam sent a message to residents in the military housing communities on Monday, reaffirming their commitment to investigating the complaints. And then Captain Eric Spitzer said that he and his staff were drinking the water. Some staff members also live in the housing and were using the water as well. So that's the information that the Navy provided to the public on the 29th, which is we're drinking it. If you smell fuel, don't drink it. Or think about not drinking it.
If I can,
Yeah, of course, Mr. Jensen. So but after Mr. Jensen, after you comment, we're just going to close it right there. Mr. Jensen, you may respond.
I would just like to point out that with regard to the newspaper article, the Navy has no control over what the news system publishes. The important point is with regard to our media release, and our media release says, not maybe, as Mr. Hickam would claim, it does say in particular, if chemical or petroleum odors are present, recommend avoiding ingestion as a cautionary measure. Thank you.
And apparently you have no control over the commander of Joint Base Pearl Harbor Hickam telling people I'm drinking it, don't worry about it.
I'm out. That's it. Okay. We'll save this for argument. The documents speak for themselves and you can argue it at the appropriate time.
The public probably won't have access to these documents. And so Mr. Jensen wanted to put on the record what they said, and so did I.
Okay. I believe that's been done.
Thank you.
So with respect to just confirm on the record, N-7O and N-7P are admitted into evidence without objection. Those can be uploaded immediately and an amended exhibit list filed. With that understanding, I believe that is the close of all pending requests. Mr. Hargrove, would you like to add anything before we close the trial record?
Would not, thank you.
Ms. Gannon?
Nothing further to add.
Mr. Henkin?
Nothing further.
Mr. Jensen?
Nothing further.
With that, the trial record will be closed. As soon as Mr. Jensen informs us that the documents have been uploaded, I will work with our DOH staff to basically close the joint database that we've been using so that it's not subject to amendment anymore. And then we will proceed. With respect to the arguments today, we have
one question. Sorry, here, just a technical issue. Will the parties still be able to access it to
Oh, yes.
download?
Yeah, so basically it'll just prohibit uploading.
Wonderful. Thank you very much.
With respect to today, we have 15 minutes apiece for closing arguments. The order of presentation is the reverse order of the evidentiary presentation from yesterday. That means it would be first the Navy, second Sierra Club, third Board of Water Supply, and fourth the Department of Health. I would like, if possible, just to make sure that the hearings officer has what I believe to be the correct framework of what is at issue in this case. I'll just briefly state my understanding of the issues, just basically the skeletal issues in this case. And you can tell me if I'm correct or incorrect, but I think that would be helpful to me in this argument. So basically, the hearings officer views the emergency order as borne out in the evidentiary hearing as having essentially two separate, albeit related emergencies. The first is the release on November 20th, 2021, and the ongoing response. This concerns, in the emergency order, there are 5 enumerated orders, or I'll just call them the enumerated orders. This first emergency would concern 1, 2, and potentially 5. 1 concerns the immediate suspension of operations primarily. The second concerns the installation of a drinking water treatment system or systems. And then the fifth is basically about taking corrective actions. The second alleged emergency is broader and concerns the systemic problems with the continuing operation of the Red Hill bulk fuel storage tank at the current time at any fashion. And this is all 20 tanks. And this primarily concerns emergency orders enumerated as 3 and 4, which primarily concern the defueling of 20 bulk fuel storage tanks. And again, order 5 could relate to both the first emergency or the second alleged emergency. I believe that my take on it is they seem to be separate but related. I would like a statement from each party whether they agree with that characterization or not. And with that, Mr. Jensen, if you'd like to proceed.
Yes, sir. Good morning, hearing officer Day, council, and everyone watching. To a certain extent, the evidence presented and the arguments made by the 4 parties to this hearing are like 2 ships passing in the night. On the one hand, you have Department of Health, Board of Water Supply, and Sierra Club, and they're focused on the what if this and what if that. And on the other hand, you have the Department of the Navy, and we're focused on what happened. How did the release happen? What did we do to isolate the contamination? What did we do to take care of our people? And what are we doing to clean up the mess? An emergency order must focus on what's happening now or just about to happen. What is the imminent peril and how to handle it? Today, on December 21st, here is where we are. The emergency was realized. The Navy immediately responded by doing all things that you've heard. And because of that, there is nothing happening now or just about to happen that an emergency order needs to deal with. The last release from an underground storage tank was in 2014. And in 2015, the Department of Health, the EPA, the DLA, and the Navy mutually agreed on an AOC, an administrative order on consent, to address that release and to work cooperatively to protect drinking water, the human health, and the environment. The May and November releases were not from a tank farm, or were not from a tank. They were from pipes. And there is good cause to believe, as you heard yesterday, that the 2 releases are related, because the pipe in the November release was an AFFF pipe, a fire suppression pipe, which shouldn't have been holding fuel, had to have gotten the fuel from somewhere, and most probably got the fuel during the May release. That's under investigation, but that's what we know now. My point is that these releases, or indeed one release, the May release that ended up in the pipe and then subsequently was discharged from the pipe, the AFFF pipe, do not support a what if tank release. There are a lot of tools in the Department of Health's Board of Water Supplies and Sierra Club's toolbox to address the what if. The AOC is one, and the Department of Health agreed to it. Navy's role, as you've heard yesterday, is to produce deliverables. And we've done that. For example, the groundwater model was submitted in March of 2020. They've spent a year and a half talking about it and thinking about it. We've asked for formal comments on it, which they have not yet sent. They haven't engaged in the process they've agreed to. And now the Department of Health wants to use this process, the AOC itself, and their own dereliction within it as a basis for the emergency order. The permitting process is another regulatory tool, and Board of Water Supply, Sierra Club, and Department of Health, through the Environmental Health Agency, brought a contested case hearing over whether a permit should issue. The administrative order of consent is still in effect. It is working. Department of Health and the Navy remain engaged in that process, and 6 years later, there have been no further tank releases. The best evidence that our improvements are working. The permitting process is also still underway, and the Navy, Department of Health, Board of Water Supply, and Sierra Club are still very much engaged in it. Best evidence of that, the other three parties have moved to reopen the hearing to present the evidence that you heard yesterday, and undoubtedly a great deal more, given that that contested case hearing will not be confined to the one day that you had from the Department of Health to consider the matter. But let's take a moment and address the what if. Okay, let's talk about the what if. Red Hill, as you heard yesterday, the underground storage tank system has a series of interlocking safety systems to prevent releases, and if there is a release, to detect them. And that second part is important. Tank tightness testing, you heard about that. It's our leak detection method. We conduct it twice a year, even though the regulations only say we have to do it once a year. It takes days to conduct. It's performed by professional engineers, not the Navy, contracted professional engineers. And we've done it, and all active tanks have passed the tank tightness testing system. TERM is the Tank Inspection, Repair, and Maintenance Program. It's the industry standard approved by the American Petroleum Institute, and includes the non-destructive examination that you heard all about. It is also Department of Health approved. Automated fuel handling equipment. You heard about that from Captain Meyer. These are the fuel monitoring systems that gauge the fuel, work the processes. It works. It works in September in that incident that has been reported where there was no fuel release, but there was a problem with the system. It worked. Groundwater monitoring. You heard evidence on that, and you saw graphics on that. We prior to 2014 didn't have a lot of groundwater monitoring stations. We now have more than 20, and we're working to get more. Soil vapor monitoring. You heard about that too in the Department of Health testimony. They're early warning sentinels that something has gone wrong, that there's a problem in the tanks potentially, and that there's a leak. They're counters. These soil vapor monitoring systems are counters to any claim that a tank could be leaking a small amount, and we would never know. And on these 5 systems, it's important for the hearing officer to understand, I think, that the only measure that's in the Department of Health underground storage tank regulations is the tank tightness testing measure. And that's once a year. The other systems, the other things I've just talked about, go above and beyond. Why does the Navy do it? Well, it's the right thing to do, obviously, but also because it was agreed to by Department of Health, EPA, and DLA. And it was designed to account for any special risk that might be present in the Red Hill underground storage tank system. So, and I'm going to get to your point now, sir, with regard to what does the emergency order offer and what should we, how should we think of it? Okay, we have an emergency order here. I'm going to talk about justification first, and then I'm going to talk about the directives. So we have an emergency order here without proper justification. First, the first justification cited to the emergency order are a number of alleged failings with regard to the AOC deliverables. We already talked about that. This justification is not in the form of an emergency, let alone imminent peril. There are disagreements on analysis, disagreements on experts, There's a resolution process in the AOC with regard to these disagreements on deliverables. The Department of Health has never exercised it. They can't, honestly, because they haven't even gone through the process of working it out with the Navy yet. We ask them for documents and they don't give it to us. So how can they move forward with their dispute resolution process there? That's one question, kind of irrelevant to this hearing. More relevant, how can they use that as a basis to claim that that is proper justification for an emergency order? It's just not. Second, the order lists what they allege are the 5 releases. The first, in 2014, as I already told you, was the impetus behind the AOC. A release in 2014 cannot justify an imminent peril determination in 2021, especially when the parties decided, including the EPA and DOH, decided that the proper vehicle to address that release is an administrative order and consent, which is what we all agreed to do. So that one's out. 2 additional releases, Hotel Pier and Kilo Pier. You didn't hear a lot about these, probably because all the parties recognize they're not really relevant, but I'll give you some information that you'll be able to see in the record and in our briefs, okay? First, they're pipe vents. They're not tank events. Down at the harbor, 4 miles away, they're not up here, okay? And they're adjacent to surface waters, not the groundwater, all right? So those are important points. Plus, and significantly, those issues were both addressed on a practical and regulatory matter level. So they've been addressed, they've been resolved, and they were resolved consistent with what the regulators told us to do. So no one is at risk. And then finally, you have the May and November releases that are most probably connected, as I've already discussed. Importantly, the contamination source was isolated, people were protected, and cleanup is ongoing. Okay. So third, the order cites the contamination at Red Hill, suggests the contamination may have been a result of the May and November releases, and argues that Red Hill lacks infrastructure to deal with this. Okay, got that. We all agree, okay? There was probably a connection between the May and November release. And we have very good reason to think that the November release was the cause of the contamination to Red Hill. But the Red Hill shaft is closed down and will not reopen until water meets EPA and DOH requirements. Okay, that's important, number one. And on infrastructure, DOH wants drinking water treatment systems. The Navy wants drinking water treatment systems. We've already went out and purchased large GACs and are using them right now to clean out the distribution system of the Red Hill well. And we have even larger GACs, multi-million dollars, $20 million worth of GACs on their way that we're going to apply to the wellhead once we get a permit from Department of Health, because we would not do that without getting the permit from them, and use that to flush the water, okay, out of the well, treat it, okay, and put it back into the system. So those are the justifications. I just ran through all of them with you, and none of them support an emergency order. Let's talk about the directives. Directive 1. That the Navy immediately suspend operations at the bulk fuel storage tank. Well, as you know, the Navy's already suspended operations at Red Hill, and the Navy's suspension will continue at a minimum until the investigation into what happened at the Red Hill shaft and how it was contaminated is determined. And that makes sense, okay? A forever suspension is not appropriate. Find out what happened, you make sure the processes you have in place address it, and then you move forward. That's not what the emergency order does. But importantly, with the suspension, there is no emergent need to take any other action or to take another type of expansion to protect human health and the environment. Directive 2, that the Navy take immediate steps to install a drinking water system or systems at the Red Hill shaft. I've already talked about that, so I won't, we're doing it, all right? And that's important. Another important point is, just because a provision within the emergency order is a good idea doesn't mean that it substantiates or it validates the emergency order itself. Okay. And I think that's important. Directive 3, submit a work plan and implementation schedule to safely defuel the bulk fuel storage tanks. Well, the Navy's order says instead that the Navy will develop a work plan to conduct necessary repairs. Look, we have it right. Department of Health has the cart before the horse. They have it wrong. The Department of Health has presumed defueling is necessary and worked backwards to get to defueling. Okay. We instead are directing the same type of analysis be done. And however that analysis comes out, we will do the things required from that analysis. Secretary Balaki said on the stand yesterday, if that thing includes defueling one or more tanks, we will do it. So again, we're not putting the cart before the horse. We're working as we should chronologically moving forward. Directive 4, defuel the bulk fuel storage tanks at the facility. So again, the last release from an underground storage tank at Red Hill was in 2014. And we all know that it was caused by contractor error. The Navy has a robust program to ensure that the continuation of the integrity of the tanks. The recent releases, the ones that everyone complains about, are from pipes, not tanks. And one of them was from an AFFF pipe, which isn't even a fuel pipe. Assuming there is imminent peril, therefore, which there is not, an appropriate order would address deficiencies in the pipes, not the tanks. Directive 4. I'm sorry, I just discussed Directive 4. Directive 5. Submit a work plan to determine deficiencies that may impact the environment and develop correct recommendations for corrective action. The SECNAV memo contains nearly identical language. And again, I'll make the point. The mere fact that some of the emergency orders provisions are good ideas is not the legal standard for whether an emergency order is appropriate. The stakes are high. Secretary Balaki has told you that the Red Hill bulk fuel storage facility is a critical national security asset. The burden is on the Department of Health, and they can't meet the emergency order standard. On the medical piece, you heard from Dr. McGinnis that based on what he knows, he does not anticipate any long-term health impacts. If that's not good enough for you, Dr. Felton, Department of Health's toxicologist, said the same thing. And she shared that both with you yesterday at the hearing and in public forum, at least 2 Fridays ago. And their opinion is based on medical and toxicological expertise and direct knowledge of both patient dose and exposure. And while Mr. Brown attempted to cross Dr. McGinnis with regard to textbooks, it's important to understand that he has the experience from the last 20 days, 25 days, to come and the expertise to come to his opinion. And I would note that Mr. Brown did not choose to cross-examine Dr. Felton with regard to her position. The Navy has isolated the Red Hill shaft and suspended operations at the underground storage tank facility and is taking
15 minutes has elapsed.
You may sum up.
Okay. It's taking care of people in extraordinary ways. The Navy is testing constantly and continues to confirm that the only well impacted is the Red Hill well. In addition, we're purchasing clean water or drinking water systems, treatment systems. Yes, pumping draws contamination to the wellhead. Sherry Ng told you that yesterday on Direct. And that's why we have 2 larger GAC systems, which are expected to be here within roughly 2 weeks, and for which we're seeking a permit from Department of Health that will flush and treat the Red Hill. That is so important. Once again, the Navy is not saying that the contamination at the Red Hill shaft was not significant. It was. And the Navy and I personally am deeply, deeply sorry for the impact of that contamination on the lives and the people of Oahu. What we are saying is that our efforts to address this issue have mitigated the immediate impacts and kept any further significant impacts from happening. No one is at actual risk of harm today, and there is no justification for any provision of this order. Subject to your question, sir. Thank you very much.
Deputy Attorney General Hargrove.
Parties, council, members of the public, as we barrel towards the season, it's rapidly approaching. I'm reminded of a classic tale whereby a stubborn man is visited upon by his colleague, Jacob Marley, who warns his old friend of imminent peril. Then before the stubborn man appears three ghosts: Christmas past, Christmas present, Christmas yet to be. We heard yesterday evidence of past historical releases, faint memories now, poorly documented, many happening long before environmental laws and regulations were in place. But somehow their presence still haunts us to this day. Their presence is felt in the core samples, stained with oil from underneath the Red Hill tanks, the soil vapor, which still detects hot weathering, slowly degrading old fuel. And last but not least, petroleum in our groundwater, some of which has a chemical signature that suggests it was lost long, long ago. There is no way to get that out of the mountain. I suspect it would take more dump trucks than even the Navy could airlift, and I suspect most of the folks that live on Oahu would miss Red Hill if it were to be removed. We can't get it out of the groundwater either. You can't stick a straw and suck it all out. It doesn't work. You heard Phoenix Grange explain why that doesn't work. Historically, it doesn't work. It was once thought to maybe work, but it kind of just doesn't. Then we heard about the present releases, of which there are quite a few, as Mr. Henkin described earlier, 2 in 1 year, not good if you're performing statistical analysis. But do we really know that these are the only ones? Do we know that we would even have found out about this one, but for the fact that kind of everybody in military housing had to stop using their water, which is sort of an inconvenience? Do we know how much was lost? I suspect we don't. I hazard to guess we never will. Does it seem plausible that on May 6th, of the 1,618 gallons of fuel, they recovered 1,580 gallons, leaving only 38 gallons in the environment? Yet we see spikes in the TPH in the groundwater that suggest far greater. Does it seem plausible that on November 20, 14,000 gallons were estimated to have been lost by the Navy, but were miraculously also recovered by the Navy? Yet 100,000 people are still without safe drinking water. None of this makes any sense, which is exactly why you heard Captain Meyer politely concede that the Navy's investigation is a work in progress. I would argue that Red Hill as an underground storage tank system is a work in progress. But this work should not be done at our expense. Like an anvil on a fraying thread hanging above our head, the fuel should not sit on top of our aquifer while the Navy tries to figure out what is going wrong and what it can do to fix it. The Navy can take all the time it wants to fix all the myriad problems we heard about yesterday once the fuel, i.e. imminent threat, is removed. The threat is the fuel, not the Navy's incompetence. The Navy incompetence simply demonstrates how real and present the danger is. These present releases, like ghosts, a genie, if you will, they're out of the bottle, but you can't put them back in. Like the genie in the fables that gets out of the bottle, it causes chaos. Military families scrambling to find clean water to wash their babies, hotels to find room for them during the holidays, no certainty when they'll be able to return to their own homes. The Navy is chasing that genie. Airlifts of water treatment equipment at great expense to the taxpayer, wishing maybe that money had been spent on preventative measures rather than trying to clean water that was, well, it was clean before they poisoned it. Flushing contaminated water, dumping that water all over the land above Pearl Harbor. Then there is the ghost of Christmas future. Future releases that have yet to happen but are almost guaranteed. She ain't getting any younger. Even by the Navy's own estimation, this 80-year-old facility is corroding and it will leak. It doesn't like its contractors that tell the Navy what it doesn't want to hear. They don't agree with the contractors, but nevertheless, that's what the Navy's stuck with. By the Navy's own estimate, chronic releases have a probability of over 5,000 gallons per year. Note that Dr. Norfleet, the Board of Water Supply's witness, strongly suggested, I think his opinion was that it was a gross underestimate of the risk, certainly in light of the more recent ones. And they cannot prevent them. And they will come. There's no cathodic protection, despite the fact that the tanks are in a corrosive environment. The process that the Navy refers to as NDE, this is a non-destructive examination using electromagnetic imaging, has a success rate basically of 60%. I don't think anybody would be happy with the 60. My second grade teacher would have been very frustrated with me, and I would have gotten some letters home if I got 60% of the questions right. Ridiculously behind schedule. I don't think they're even bothering to try and catch up. There's no evidence that the Navy can catch up, even if they want to. Some of these tanks are 38, 40 years without inspection. This does not inspire any confidence in their ability to operate a system. How often do you change the oil in your car? It has to be properly maintained, or you won't expect it to start. And by the way, if your car started 60% of the time, would that be a car you'd keep very long? And there's all this talk about release detection, but this only lets you know the fuel is gone after it's too late, and assuming that it even works. You heard from both Lene Ichinatsubo and Dr. Norfleet that chronic releases in particular can go undetected by most release detection methods. Finally, you heard Ms. Ng continue the Navy's insistence that its groundwater modeling is useful when the Department of Health has repeatedly advised them that they are both ignoring available data, making false assumptions. The Navy has yet to even complete its fate and transport model, the purpose of which is to inform the Navy of the imminent peril it is today continuing to ignore. Again, it doesn't want to know. The Navy does not want to know the truth because the truth makes it incredibly inconvenient for the Navy to continue to operate this facility. They have this magical capture zone that conveniently under the Red Hill tanks will capture the releases, these future releases. They will magically hide without affecting the drinking water. Even if this were true, which the department clearly said in its presentation, this is Phoenix Grange, said clearly it is not true, it's still a ticking time bomb of contamination sitting above the aquifer in a poorly characterized geology. It's in the environment. They're just saying it won't ruin your drinking water. I would not take that bet. The Navy says the geology under Red Hill is like a sponge, that it will hold future releases, yet this conclusion is not scientifically supported. The Navy's estimated holding capacity, 2,600,000 in 2018, revised down to, well, let's just say 66,000 to 112,000 in 2021. I suspect the Navy may want to revisit its estimate of how much can be held in the Red Hill sponge now that we've seen what happens when you have a release right under the tanks of an unknown quantity with a direct pathway to the groundwater. The question for the Navy now is, having seen the ghost of Christmas past, present, and future, why is now not the right time to move the fuel? Why not remove the threat and take the time to figure out what the vulnerabilities are? Why insist stubbornly that the fuel cannot be stored somewhere other than above our aquifer? Dickens didn't write a Christmas story, he wrote a morality tale about how it's never too late to do the right thing. We should not have to wait for the Navy to come to this realization. We don't have to wait for them or for the harm to occur. 342, L9 envisions action to be taken where there is or will be caused an imminent peril to human health from the operation of a UST system. Let us visit what Mr. Jensen said in his closing. An emergency isn't only what is happening now. I mean, can you imagine if the Department of the Navy was running the Park Service and they had Smokey the Bear saying, instead of only you can prevent forest fires, the slogan was only you can put out forest fires. You have to prevent. You can't wait for the forest to be burned down before you take action. Certainly the Department of Health does not have to wait. And Mr. Jensen creates this false dichotomy that Mr. Hinken touched upon earlier between the tanks and the piping. You can't have fuel in the piping without fuel in the tanks. There's a large volume of fuel in the tanks, and they're of no use to the Navy unless they get out of the tanks. Best case scenario, they go through secure piping from secure tanks. But what you've heard is they are not. They leak, they're corroding, they can't fix them, they're not even sure where to fix them, and they can't fix them on time. Mr. Jensen and the Navy are using the administrative order on consent. The AOC is covered. We did not know then what we know now, and we certainly were not aware in 2014 that we were facing an imminent peril. That is the difference Mr. Jensen conveniently ignores. The AOC was not addressing an imminent peril. It was addressing a problem that all the parties agreed may be solved over the course of time. We have, through that process, learned a lot more, and then all of a sudden, we see the tracer test this month, end of last month, that the Navy has for many years refused to do. Only not with an innocuous dye that causes no harm, but with fuel, jet fuel. That jet fuel went straight from their tanks to their families' taps. Jensen even acknowledges, Mr. Jensen acknowledges that the EO is a good idea, but as Mr. Hinken explained quite eloquently, the Navy just doesn't want to do anything other than what it wants to do. It does not want to be ordered to do anything, and it's just refusing to even take its own advice, which is take a breather, figure out what's going on. Just wants to leave the fuel there. That's not safe. That's not a risk that we should be asked to bear. It's really then not a question of whether or not the department can exercise its emergency power in this case, but how rather it could not in this case. So with that, the Department of Health asked the hearings officer respectfully to affirm the emergency order in its entirety. And I would like to thank counsel and the hearings officer for affording us this opportunity to deliver this argument. Thank you very much.